Everybody talks about these questions, but what is said about them lacks the minimum of clarity without which talking becomes a harmful operation. Because talking always has certain consequences, and since talking about these subjects has become general, for years, people have practically talked about nothing else and allowed no one to talk about anything else. The consequences of all this chatter are, obviously, very serious. This is a quote that can be found in the description of practically all of my videos. And as you're going to see, it applies perfectly to the abortion debate being had in the United States today. And not just today, but that has been being had in the United States for the better part of the last century. Now, because the topic of this video has been made into such a partisan conflict, I'd like to start this video off by giving a general statement on where I stand on this issue. For a long time, I believed that abortion should only be legal when it comes to rape, incest, the physical health of the mother, and I kind of emphasize physical health of the mother over the mental health of the mother, birth defects, or anything done within the first trimester. If she wants to get an abortion for any reason in the first trimester, by all means, go at it. And I think that most people also feel this way. And although this is what I continue to believe, I've recently updated this belief to simply, I don't entirely agree with people who are pro-abortion or who are pro-choice. I'll fight for them to have the freedom to get an abortion at virtually any stage. If you want to get a late-stage abortion because of your mental health, go right ahead. End the potential life of your unborn child. Damage your uterus, making it more likely for you to have a miscarriage in the future, and potentially damn your immortal soul. That's largely between you, whatever force is out there, whatever eternal force is out there, God or whatever, and your unborn child. That's your destiny, your eternal karma, or whatever you want to call it, not mine. Now, I'll make a separate video explaining how and why I changed my mostly conservative stance on abortion to a more liberal one, but for now I'm just going to say that if you really care about freedom, this is the best stance to have. And I'll also say that the problem that we're currently dealing with, this current problem with abortion, these current fights that people are having with abortion, are a lot like a Chinese finger trap. And it can only be resolved by giving, not resisting. All of this fighting, it's just going to make the problem worse. But this video isn't about that. At least it's not necessarily about that. This video, as you can tell by the title, is about showing why the recent Supreme Court decision to overturn Roe v. Wade makes absolutely zero sense. And this video is also going to be about how this is more evidence to me that we are living in a system that is corrupt to the bone. Because I don't think that the Supreme Court was wrong by accident, or because they're incompetent. As you will see, I believe they were intentionally wrong. I believe they intentionally made the wrong decision in order to steer society in a particular direction. Now, let's get into the facts and the evidence. In order to understand how the Supreme Court's recent decision about Roe v. Wade was wrong, we have to spend a little bit of time obtaining a general understanding of Roe v. Wade. Now, for the sake of this video, I'm going to be looking at a general summarization of Roe v. Wade that can be found on this website, oyez.org. However, during the research of this video, I did read most of the majority opinion PDF. Basically, I read what was necessary to prove that the current Supreme Court lied about the arguments made by the past Supreme Court. They basically 1984'd the past Supreme Court's argument in the most hilarious and obvious ways imaginable. But anyway, let's quickly look at the little bit of information about Roe v. Wade found on this OYES website. Let's look at the facts of the case. So it was decided in 1973. I believe there were actually 2 hearings. So it was like first looked at in like 1971 or something like that, maybe 1972. And then it was reheard in 1973. I think there was like an appeal or something like that. Whatever, it doesn't really matter. So the facts of the case. In 1970, Jane Roe, a fictional name used in court documents to protect the plaintiff's identity, filed a lawsuit against Henry Wade, the district attorney of Dallas County, Texas, where she resided, challenging a Texas law making abortion illegal except by a doctor's orders to save a woman's life. In her lawsuit, Roe alleged that the state laws were unconstitutionally vague and abridged her right of personal privacy, protected by the First, Fourth, Fifth, Ninth, and 14th Amendments. The question is, does the Constitution recognize a woman's right to terminate her pregnancy by abortion? Inherent in the Due Process Clause of the 14th Amendment is a fundamental right to privacy that protects a pregnant woman's choice whether to have an abortion. However, this right is balanced against the government's interest in protecting women's health and protecting the, quote, potentiality of human life, unquote. The Texas law challenged in this case violated this right. Justice, and then it says this guy gave the majority opinion. Now, before I discuss this, let's just look at what they stated. So, first, the court considered whether the case was moot. This part right here isn't necessarily important. The reason why the court had to consider whether or not the case was moot is because by the time the case was seen before the Supreme Court, the lady was no longer pregnant. So Wade was trying to argue that since she was no longer pregnant, the case was no longer valid. So the court, first, if you look at their PDF, they first state the reasons why they still are going to hear the case even though she's no longer pregnant. They discuss how, it would be absurd to hold that standard to pregnant women because then, any case pertaining to pregnancy wouldn't make it past the preliminary trial or something like that. They were like, okay, well, in that case, you'd have to go through all of these courts and do all of this work within a 9-month period of time. So they were just like, yeah, this case is not moot. But this is not relevant whatsoever. What's relevant is right here. So the Due Process Clause of the 14th Amendment protects against state action. They messed up on the writing here. Okay, so I'll just read this the way that it should have been written. The Due Process Clause of the 14th Amendment protects against state actions that violate the right to privacy, and a woman's right to choose to have an abortion falls within that right to privacy. A state law that broadly prohibits abortion without respect to the stages of pregnancy or other interest violates that right. Although the state has legitimate interest in protecting the health of pregnant women and the potentiality of human life, the relative weight of each of these interests varies over the course of pregnancy, and the law must account for this variability. Before I comment on this, I'm just going to just finish reading it. I'm just going to read the last bit of information that's here. In the first trimester of pregnancy, the state may not regulate the abortion decision. Only the pregnant woman and her attending physician can make that decision. In the second trimester, the state may impose regulations on abortion that are reasonably related to maternal health. In the third trimester, once the fetus reaches the point of viability, a state may regulate abortions or prohibit them entirely, so long as the laws contain exceptions for cases when abortion is necessary to save the life or health of the mother. Okay, so on its face, I think that a lot of people will agree with this. And I'm not trying to commit some popularity fallacy. I think that this is all just. I think that everything that is stated here is pretty just. It's pretty reasonable. The government claims to have a legitimate interest in protecting the health of pregnant women and the potentiality of human life. However, this potentiality of human life, let's just first talk about this. Let's not talk about the government having a legitimate interest in protecting the health of pregnant women. We'll talk about that in a second. But let's say they have a legitimate interest in protecting life. Since we have a right to life, liberty, and happiness, or the pursuit of happiness, or basically property, according to some, let's focus on the potentiality of human life. Well, the fact is that the potentiality of human life does change throughout pregnancy. Just because something has a heartbeat in the first trimester, because I believe the heartbeat begins at like the 10-week or 11-week mark, just because it has a heartbeat doesn't necessarily mean that it's going to make it to term, and it doesn't necessarily mean that it's going to be a healthy baby. It doesn't mean that it's not going to have birth defects. So, there are a lot of factors at play, and a law that doesn't consider these factors is an unjust law, and it's a law that is violating all of those amendments. I believe it was the 1st, the 4th, the 5th, the 9th, and the 14th, which we're going to be looking at. So this makes sense. Okay, now we're going to be looking at why the federal government has a duty to protect this first trimester right, because really it's mostly a right in the first trimester. Actually, you know what? I want to comment on this real quick. So basically, it's saying here is that they're giving females the right, or mothers the right, to have an abortion in the first trimester, but then also giving doctors the protection. If something happens to this mother during this procedure, the doctor is not held liable. Okay. Now, in the second trimester, I believe where it says the state may impose regulations on abortions that are reasonably related to maternal health, this is talking about regulations that have to do with the mother's health. So I believe that the regulations that they can impose here have to do with regulations on the doctor and how abortions are carried out. Like they can regulate the procedures that are used to make sure that they are of a healthy standard, to make sure that they're not going to harm the mother. That's relating to maternal health. And then, of course, here it's saying that in the third trimester, and I believe the third trimester, I guess I should have the information here. Let's see if I have it. I don't. That really sucks. I should have the information here as to when the third trimester starts, but I believe it starts sometime in like the mid to late 20-something weeks. I think it's like 25 weeks or 26 weeks or 27-week mark. And this is pretty reasonable because I believe like the earliest born baby, or like the most prematurely born baby that survived, was at like 21 weeks or 22 weeks or something like that. So maybe they can revise this whole birthing process, this whole trimester thing, where they can say, you know what, we'll say towards the end of the second trimester is when they can start banning abortions because we've proved viability at that point. They can say, oh, we'll follow the science. These people love to follow the science, with their age of reason. So they can say, hey, we're going to follow the science and we're going to ban abortion at this point. So some points that I want to make here, though, before we look at these amendments, some points that I want to make here is that most conversations about Roe v. Wade seem to totally ignore this. People are like, oh yeah, Roe v. Wade gives us the right to have an abortion. It doesn't technically give them the right to have an abortion because it allows the state to ban abortion at the third trimester. However, actually, I almost forgot to say this. However, it is important that this loophole, because it doesn't save the physical health of the mother, this loophole can be used to get an abortion basically at any time, even, any time in the third trimester, for the mental health of the mother. Now, I can say a lot about this, but, mental health is important. If a person's mental health goes to shit, then they can end up harming not just themselves, but then those people around them. We've seen mothers who have terrible mental health ending up killing all of their children past birth. Okay, we're talking about their like preteen children and their teenage children. So mental health is important. The point is that technically Roe v. Wade does give this loophole where you can technically get an abortion at any point for the mental health of the mother, to save the life or health of the mother. But the point is that most people that talk about Roe v. Wade, they don't talk about it correctly. Just like the quote that I started this video off with, everybody talks about these questions, but what is said lacks the minimum of clarity without which talking becomes a harmful operation. We are all trying to come up with theories about life and about government and about these things in very, very muddy waters, where words are not being correctly used. I mean, all kinds of issues. And I've proven that with previous videos. So let's look at the 1st, 4th, 5th, 9th, and 14th Amendments and see how they really apply to protecting a woman's right to an abortion. So the First Amendment. Now clearly there's nothing here in the First Amendment, and I'm sure anybody familiar with the First Amendment, they're probably scratching their heads like, wait a second, what does the First Amendment say about privacy? Well, let me explain, and this also goes back to them not talking about this problem clearly enough. It has more to do with the religion aspect of the First Amendment than it has to do with anything else. So let's look at the First Amendment. So, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances. So people are like, oh, what does it say about abortion there? Well, this has everything to do with religion. And anybody who looks at the PDF of the Roe v. Wade court documents can see this. So I believe this is not the syllabus. I believe this is actually during the oral argument of the PDF. Not important, though. So Part 6, point 34. The judge at this point, he says, it is perhaps not generally appreciated that the restrictive criminal abortion laws in effect in a majority of states today are of relatively recent vintage. So here the judge is basically talking about the restrictive criminal abortion laws that were in effect in a majority of states at this time. And he says that those laws are actually relatively new. And he says that those laws generally prescribing abortion or forbidding abortion or its attempt at any time during pregnancy, except when necessary to preserve the pregnant woman's life, are not of ancient or even common law origin. Instead, they derive from statutory changes effected, for the most part, in the latter half of the 19th century. Now, this is really important that this is highlighted because the current Supreme Court basically lies about what the past Supreme Court says about this. And we'll be getting into that later on in this video. But the point that he's trying to make here is that these abortion laws that forbid abortion at any point during the pregnancy are new, and they don't come from either ancient or even common law origin. And then he says that, they derive from these statutory changes that took part in the latter half of the 19th century. Then he looks at point number 35. He looks at ancient attitudes. This is what he does. So, this is his statement, and then he breaks this statement down. And first he looks at ancient attitudes. And then basically what he does when he looks at ancient attitudes is he shows that, yes, abortion was forbidden in some places, like the Persian Empire, but in other places, like during the Roman era and during ancient Greece, abortion was practiced very liberally. It was practiced without scruple. And there's a lot of evidence for this. Some of the evidence that they show for this is he looks at the Ephesian Coronos, often described as the greatest of the ancient gynecologists, appears to have been generally opposed to Rome's prevailing free abortion practices. So even this gynecologist, who wasn't very happy with Rome's prevailing free abortion practices, even this gynecologist, he would perform abortions, or he would resort to abortions when he felt the procedure was necessary to preserve the life of the mother, or when he considered the life of the mother. Now, we don't really know if he's concerned with the physical health of the mother, or if he's concerned with the mother's life in general. So then this judge also states that Greek and Roman law afforded little protection to the unborn, and if abortion was prosecuted in some places, it seems to have been based on a concept of violating the father's right to his offspring. And then they state that ancient religion did not bar abortion. And actually, it should also be known that if you look up infanticide, even in Rome, like infanticide, and in ancient Greece, and in other ancient cultures, infanticide was practiced up into a certain age. I believe it was like until the child could speak in some cultures, and in other cultures it was until like the child stopped breastfeeding or something like that. But the point is that the way that people felt about abortion in the past was very different than the way that people currently start to feel about abortion within the last 200 years or so. And then infanticide itself, the laws did come about not just in the last 200 years, but infanticide, these laws against infanticide started during the Roman Empire. I believe it was like something like 200 AD, or maybe like 100 AD or something like that. I guess I should have had that information here. I should have taken a screenshot of it when I was reading it. But anyway, the point is that the judge is trying to establish this point that attitudes, that people's beliefs on abortion has changed over the ages. Then the judge looks at the Hippocratic Oath, and then basically, I'm not going to read all of this, he basically says that yes, although the Hippocratic Oath states that they will not give an abortion, it says that I will neither give a deadly drug to anybody if asked for it, nor will I make a suggestion to this effect. Similarly, I will not give to a woman an abortive remedy. So the judge basically gives evidence, or the court gives evidence, that the Hippocratic Oath wasn't always the same everywhere. So then after presenting the Hippocratic Oath, they ask themselves, well, if the Hippocratic Oath says this, and the Hippocratic Oath is like this many years old, how come there was still such a widespread use of not just abortions, but there was also a widespread practice of infanticide? And it also seems like, according to Greek law, abortion was legal before quickening, which is before the baby showed any signs of life or had any movement. And then basically the court says that the reason that this was the case had to do with a difference in belief systems. And they basically they say that the school that that part of the Hippocratic Oath represents comes from the Pythagorean school of philosophers, and they held a dogma on abortion because they believed that an embryo was animate from the moment of conception, and abortion meant destruction of a living being. So the abortion clause of the oath, therefore, echoes Pythagorean's doctrines, and in no other stratum of Greek opinion were such views held or proposed in the same spirit or uncompromising austerity. So basically, they're just the court says that like only a small group of people actually believed this, and the reason why they were against abortions had to do with their own belief on when they believed life began. And then they provide a little bit more evidence to that. Now, of course, this all goes into the First Amendment and the belief system, one's personal beliefs. One can have a personal belief that that life starts, at conception within the first trimester, and then other people can say, no, it comes later on. So what the court decided was that, we're going to settle for the obvious, and we're going to say that life begins in the third trimester, where there's movement and there's viability, which is what they termed it, viability, which I think is pretty reasonable. Saying, okay, well, you can have your beliefs, but we're not going to base it just on your beliefs. We're also going to base it on empirical reality. And in my opinion, I think that the court chose a good middle ground for their time. And maybe it could be revised. Maybe that would have been a better thing for the current court to do. Alrighty, so after that, let's look at the Fourth Amendment, because they said that the Fourth Amendment also protects this right to abortion. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, the way that the Fourth Amendment plays into this is that this is basically the basis for privacy. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. So, what the court decided during Roe v. Wade is that the first trimester would be deemed unreasonable. Even the second trimester, when it's pertaining to the baby itself, would be unreasonable according to the Supreme Court at that time. But then they deemed that the third trimester would be the point where it would be reasonable to not put, I guess, searches and seizures, but to start putting laws, regulations on this personal thing, on this thing that a person does with themselves and their unborn child. So that's how the Fourth Amendment ties into all of that. So now let's look at the Fifth Amendment. So no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. Let me just jump ahead because we really don't have a lot of time. So the part of the Fifth Amendment that protects abortion is this last point over here. It's nor shall be compelled in any criminal case to be witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So the part of the Fifth Amendment that will protect the abortion in the first trimester is the due process, is being deprived of life, liberty, or property without due process of law. And the liberty that they would be getting deprived of is not necessarily this liberty to abortion at any time, in any place, but it's to have an abortion in the first trimester. It's to have that privacy in the first trimester, and not just the privacy in the first trimester, but the privacy in the first trimester because of their beliefs that life doesn't begin until after the first trimester. So they're actually defending two rights here. So the Fifth Amendment is supposed to be defending those two rights. And now I emphasize this because every single time I hear a person talking about Roe v. Wade and abortion, they always talk about the right to privacy, but they never talk about this right to belief, this freedom of consciousness. And now, I want to state also, for the record for this video, I know the video is already really long, I probably already lost most viewers anyway, but for those people who are still watching, I have a previous video, a much older video, where I look at the original amendments that were proposed for the Constitution. A lot of people don't realize this, but the people who proposed amendments to the Constitution, some states had actually proposed like up to 30-something amendments to the Constitution. And one of the amendments that the First Amendment eventually, was supposed to cover was a freedom of consciousness. They didn't want a freedom of religion. They wanted actually a very explicit freedom of consciousness. Freedom to think what one wants to think or believe what one wants to believe, even if it's not a religious or deemed a religious belief. Because they, at the time, argued, well, hey, look, you can just deem that a conscious thing that I feel or something that I believe has no religious connection. And that's largely what they have done today when it comes to the vax mandates. Today when it comes to the vax mandates, a lot of people who put forward an exemption, who asked for an exemption because of their own personal beliefs, a lot of them were denied because it was deemed that the vax mandate didn't violate like a fundamental part of their belief system or some nonsense like that. And this is exactly why they wanted the freedom of consciousness. But anyway, I digress. I think I said everything that I wanted to say with that. So now let's look at the Ninth Amendment. So the Ninth Amendment is the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So basically, the Ninth Amendment is that, like, the rights that are here in the Constitution are not the only rights that these people have. Like, the rights that are enumerated in the Constitution should not be construed to deny or disparage other rights retained by the people. The courts cannot be able to look at the Constitution, say, oh no, look, that right is not there in the Constitution. It's not explicitly covered by the Constitution, so you don't have the right. So that's what the Ninth Amendment clearly says. And of course, the reason why this is because the people who were asking for amendments on the Constitution were asking for a hell of a lot more rights on the Bill of Rights than the ones that are listed there in those first 10 amendments. So in the other amendment that's supposed to protect a woman's right to get an abortion in the first trimester, or actually it's the first and second trimester, whatever, is the 14th Amendment. And this one states that all persons born or naturalized in the United States and subject to the jurisdictions thereof are citizens of the United States and of the states wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. So you got the equal protection clause here, and then the due process clause, which is just basically restating what is stated in the Fifth Amendment, that you cannot be deprived, or no person shall be deprived of life, liberty, or property without due process. So that's basically how those amendments cover it. Now, as you saw, even the Yes article, when they covered the Roe v. Wade conclusion, they really only mentioned the 14th Amendment and how the due process clause protects the right to privacy. Never any mention, really, about how the First Amendment applies to this. But anyway, before we move on to the current Supreme Court's PDF, I just want to make it clear to the audience why this is a federal matter, why the federal government has the authority to tell the states that they cannot put a restriction on abortion in the first 2 trimesters. And of course, that's because these are rights protected by the federal Constitution. Alrighty, now that we have a pretty solid understanding of Roe v. Wade, or at least hopefully a better understanding of Roe v. Wade, let's turn our attention to the current Supreme Court decision, or the current Supreme Court case that overturned Roe v. Wade. So for this video, we're just going to be looking at the syllabus. However, just like with Roe v. Wade, during the research of this video, I did read a majority of this argument put forward after the syllabus. We're not only going to read the syllabus, I'm probably going to present like 1 or 2 pages from the argument. Like I'll present the opening argument put forward by the majority opinion. But for now, let's just wrap our head around the syllabus. So this case was over a Mississippi act that banned abortions for babies, or for unborn children, or for an unborn human being that was determined to be greater than 15 weeks. So Mississippi was like, you know what, we're going to ban abortions after 15 weeks, or anything greater than 15 weeks. We're going to forbid, or we're going to ban them. And this, of course, would violate Roe v. Wade, which stated that they can't ban them until the 3rd trimester. And the 3rd trimester, I'm pretty confident, is like the 27th week, or something like that. Not important. So what's important is that they banned it at the 15-week mark, which is during the 2nd trimester. So they use some pretty interesting wording here. So, like, that this act violates the court's precedents establishing a constitutional right to abortion. In particular, Roe v. Wade, like, they should have really stated a constitutional right to abortion in this time period, in the first and second trimester. They shouldn't have really stated like a constitutional right to an abortion, because Roe v. Wade, as we looked at it already, it didn't really establish a constitutional right to an abortion, indiscriminately, without any standards or regulations or anything like that. It's like, no, there's a constitutional right to an abortion with an asterisk next to it. There's other things that need to be known and addressed and factored in to this to the statement. So the district court, this is the court before the Supreme Court, the district court granted summary judgment in favor of the respondents and permanently enjoined enforcement of the act, reasoning that Mississippi's 15-week restriction on abortions violates this court's cases forbidding states to ban abortion pre-viability. So at least that's good. At least, like, the district court made it very clear that this abortion, or that this act, banned the court's precedents on states banning abortion pre-viability. The precedent was that states cannot ban abortions pre-viability. So the Fifth Circuit affirmed this. Now, before this court, petitioners defended the act on the grounds that Roe and Casey were wrongly decided, and that the act is constitutional because it satisfies rational basis review. Okay, so the people who are defending the act, the argument that they put forward to the Supreme Court was that the act is actually justified because Roe and Casey were wrongly decided, and that the act is constitutional because it satisfies rational basis review. The rational basis review is very simple, that the state has a rational interest in the life of the unborn child. Okay, so let's look at what they said. So they said, the court held, the Constitution does not confer a right to abortion. See, this is, once again, like, this really bothers me. It's like, nobody ever says that it really confers a right to abortion, like, in this blatant way. Roe and Casey are overruled, and the authority to regulate abortion is returned to the people, quote unquote, the people. It's not actually given back to the people. It's given to the state governments and their elected representatives. Now, I'm going to make a separate video of how the current government gets away with this the people nonsense. The people is basically the elected representatives, and the elected representatives basically are the government. It's the state governments, and those state governments, guess what? Those elected representatives, they don't represent the people at all. Okay, I can show example after example after example of how they do not have the people's interest in mind, and how when they appear to have the interest of the people in mind, they're really just pretending, and it's actually just a gigantic ruse, as it's always been with the government. Okay, so this is really important to acknowledge this. And this is actually a point that I really want to make clear, is that the Supreme Court, we're going to see this in their rhetoric, and the rhetoric with the people on the right now, the rhetoric coming out of the people who are part of the conservative cult, because there's a cult on the left, there's also a cult on the right, but the rhetoric coming out of that cult is that this ruling is a good thing because it actually gives people more rights. Like, that's actually what they're trying to say. Like, oh yeah, we're giving rights back to the people. But by back to the people, they mean to the state governments. And that's why they use the term authority. They don't say, and the right to regulate abortion is returned. It's actually an authority that's given to them. So all of these all of this wording is really freaking important. But people just kind of, they just go past it. And this all goes back to the quote that I started this video off with, where, everyone's talking about these questions, talking about these topics, but they're doing it without even the minimum of clarity that's necessary. Anyway, so then this is their statement, right? This is they hold it here, right? This is their decision. This is what they held. Now they're going to give like the supporting parts of their decision. So A, the critical question is whether the Constitution properly understood. I guess these guys are the ones who are properly understanding it. Confers a right to obtain an abortion. Casey's controlling opinion skipped over that question and reaffirmed Roe solely on the basis of stare decisis. Now, what they're talking about here is this is another court case that was heard after Roe v. Wade. And essentially, the Supreme Court here is saying that this court case did not consider this question. They did not consider the question whether or not the constitutionally properly understood confers a right to obtain an abortion, and then based their judgment solely on the basis of stare decisis, which is based on the precedent of Roe v. Wade. They go on to say a proper application of stare decisis. I like their use of proper. So properly understood, and then a proper application. They really like that word proper. So a proper application of stare decisis, however, requires an assessment of the strength of the grounds on which Roe was based. The court, therefore, turns to the question that the Casey plurality did not consider. First, the court reviews the standard that the court's cases have used to determine whether the 14th Amendment reference to liberty protects a particular right. Okay, so they're saying that they're reviewing Roe v. Wade because the case that followed Roe v. Wade did not properly review Roe v. Wade or did not properly consider the strengths of Roe v. Wade. It kind of just accepted Roe's ruling and went off of that. They're saying that they're not going to accept Roe's ruling and that they're going to themselves inquire as to whether or not the Constitution really gives this right to an abortion. So the first thing that they did was the court reviews the standard that the courts have used to determine whether the 14th Amendment reference to liberty protects a particular right. They're going to review the standard that the court has used to determine other rights that are covered by the 14th Amendment that aren't explicitly covered in the Constitution. They're going to say, okay, we're going to look at how we came to determine these other rights that aren't explicitly put in the Constitution, and we're going to see if we can apply that standard to an abortion. So, the Constitution makes no express reference to a right to obtain an abortion, but several constitutional provisions have been offered as potential homes for an implicit constitutional right. See, to me right here, actually, you know what, I'll keep reading. Roe held that the abortion right is part of a right to privacy that springs from the 1st, 4th, 5th, 9th, and 14th Amendments. And that says, see this. The Casey court grounded its decision solely on the theory that the right to obtain an abortion is part of the liberty protected by the 14th Amendment's Due Process Clause. Others have suggested that support can be found in the 14th Amendment's Equal Protection Clause, but that theory is squarely foreclosed by the court's precedents, which establish that a state's regulation of abortion is not a sex-based classification, and is thus not subject to the heightened scrutiny that applies to such classifications. And then it's like, see, these court cases. And then before I even go here, let me just clarify what they're saying here with this, the suggestion about the Equal Protection Clause. Here they're just saying that some people have claimed that abortion is protected by the Equal Protection Clause, which is that, men and women have to be seen equally. But it's like, that can't be the case, because it's not like men are allowed to abort a baby. Like, that would make no sense. But there's also been precedents that have established that regulating a woman's abortion is not the same thing as regulating a man's sperm. It's not a sex-based classification. That's why they have to state that, okay? So once again though, they're talking very ambiguous up here. But then they say down here, they say, rather, regulations and prohibitions of abortions are governed by the same standard of review as other health and safety measures. Now, we need to look at the health and safety measures, right? By the way, this is just the syllabus. This isn't them really putting forward their argument. They're just saying that this is what's covered in their argument. In their argument, they're covering these points. They're covering they have these supposed counter arguments, which are very poor counter arguments. And then they get to the point that they believe that abortions should be regulated, and prohibitions of abortions should be governed by the same standard of review as other health and safety measures. Now, let's look at some of the health and safety measures. Let's look at some of the government's standards. Did you guys know that in the 1970s, the United States government, using their health and safety standards, banned the use of a certain vitamin? It's actually not really a vitamin. It's a substance that some people believed could cure cancer, right? They banned this in the 1970s. They said, no, you cannot put this substance in your body. We're going to tell you what you can put into your body. And they claimed that the reason that they banned it is because it had a poison in it. They claimed that, it has cyanide in it, and this cyanide is a poison, and it will kill you or it will do harm to you. What's interesting is that recently, I think within the last decade, they found that this substance that they banned in the 70s, they found out that it indeed does have cancer-killing properties. It indeed does kill cancer cells. So, the United States has also done this with marijuana. They've basically banned the use of cannabis and cannabinoids for treating cancer. And they've also done this with mushrooms. So the point that I'm trying to make here is very simply that the standards that they have for prohibiting and regulating other health and safety measures aren't that good. They're somewhat tyrannical, just a little bit tyrannical. Of course, a person can rationalize them and say, oh, well, look, there's some people who are just too stupid and can't be trusted with their own body, so you just have to ban these things. I mean, why not put a label on them? I mean, you put a label on cigarettes, you put a label on alcohol, but just some things, and it just happens to be very good things, you guys ban entirely. Instead of putting a label on them, like a little warning label for the stupid people, you just ban them entirely. And what's very interesting is the court actually addresses this point. They actually address the point of bodily autonomy and, having the right or not having the right to use drugs. And just wait until you see what the current Supreme Court has to say about bodily autonomy. It's disgusting. So let's move on to the second thing that they're going to say that they're going to do. So next, the court examines whether the right to obtain an abortion is rooted in the nation's history and tradition, and whether it is an essential component of ordered liberty. The court finds that the right to abortion is not deeply rooted in the nation's history and tradition. This is, of course, a lie. The underlying theory on which Casey rested, that the 14th Amendment's Due Process Clause provides substantive as well as procedural protection for liberty, has long been controversial. The court's decisions has held that the Due Process Clause protects two categories of substantive rights: those rights guaranteed by the first 8 amendments to the Constitution, and those rights deemed fundamental that are not mentioned anywhere in the Constitution. In deciding whether a right falls into either of these categories, the question is whether the right is deeply rooted in our history and tradition, and whether it is essential to this nation's scheme of ordered liberty. And then it gives this reference to these court cases. The term liberty alone provides little guidance. Thus, historical inquiries are essential whenever the court is asked to recognize a new component of the liberty interest protected by the Due Process Clause. In interpreting what is meant by liberty, the court must guard against the natural human tendency to confuse what the 14th Amendment protects with the court's own ardent views about the liberty that Americans should enjoy. Yeah, but the thing is that the 14th Amendment isn't really explicit about the liberty that it protects. And that's why you need the court to put their views in about liberty and the liberties that Americans should enjoy, at least to a certain degree. You know, that's why judges are supposed to be these great people. They're supposed to have like a lot of integrity, and they're supposed to not just know the law, but they're supposed to know the spirit of the law and the spirit of people and the nature of government and the nature of people. If you read government documents, if you read political documents from when this government was being created, when the Constitution was being created, not just the Constitution was being created, but when the Constitution was being argued, because the Constitution was also argued, there was people who pushed against the Constitution. And in these political discourses, they talked a lot about the nature of government and the nature of people. And the court is supposed to be familiar with those things, and not just familiar with what is in black and white on the Constitution. But check out what they say here. For this reason, the court has been reluctant to recognize rights that are not mentioned in the Constitution. Look at that. So the court has been reluctant to recognize what is clearly in the Ninth Amendment. The Ninth Amendment clearly states the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. But the court is like, no, we're kind of reluctant to acknowledge those other rights. Why are they reluctant to do that? Well, if you look at the history of the court, and I'm talking about not just the current court, but the history of the court in general, they're reluctant to give up government power. They're reluctant to actually put restrictions on the different branches. They make their rulings in like very specific ways that allow the government to continue to go on unimpeded in its march of tyranny. So, guided by the history and tradition that map the essential components of the nation's concept of ordered liberty, the court finds the 14th Amendment clearly does not protect the right to an abortion. Just check out all these lies, everyone. Until the latter part of the 20th century, there was no support in American law for a constitutional right to obtain an abortion. No state constitutional provision had recognized such a right. Until a few years before Roe, no federal or state court had recognized such a right. They're just basically repeating themselves. So no state and no federal or state court recognized such a right, nor had any scholarly treatise. Indeed, abortion had long been a crime in every single state. At common law, abortion was criminal in at least some stages of pregnancy and was regarded as unlawful and could have very serious consequences at all stages. Okay, should I show that they're lying here? Actually, you know what? Let me finish reading this. American law followed the common law until a wave of statutory restrictions in the 1800s expanded criminal liability for abortions. By the time the 14th Amendment was adopted, 3/4 of the state had made abortions a crime at any stage of pregnancy. This consensus endured until the day Roe was decided. Roe either ignored or misstated this history, and Casey declined to reconsider Roe's faulty historical analysis. Now, this goes back to what I was saying about the current Supreme Court 1984ing the past Supreme Court, because this is not true. The past Supreme Court does acknowledge this. They do not ignore this, and they most certainly do not misstate this history. If anything, what they're doing here is misstating it. They don't really address this in any substantive manner. However, the past Supreme Court did. Let's look at what they did, okay? So, we know that the Roe Court, the Supreme Court that made the ruling over Roe v. Wade, didn't ignore this history because they acknowledge it in point 6, number 34. Okay, so this is acknowledged. They acknowledged that the criminal abortion laws in effect in a majority of states today are of relatively recent vintage. And this whole point here is actually them basically breaking down why these restrictive criminal abortion laws are unconstitutional. Okay, so that's actually with the Supreme Court, they're basically just straight up lying. They didn't ignore this, and they most definitely did not misstate the history. So let's look at what they said specifically about common law, because the current Supreme Court is making the claim that at common law, abortion was criminal in at least some stages of pregnancy and was regarded as unlawful and could have very serious consequences at all stages. Now, they don't really specify. I believe what we're about to look at does specify this. Maybe it doesn't, though. So in case if it doesn't specify, the consequences that it would have, and when they're saying unlawful doesn't mean criminal. Unlawful means not protected by the law. So if you actually look at the history of it, and I forget which one of these people talk about the history of it, but when you look at the history of it, the mother wouldn't have been charged with anything. However, if the doctor who performed the abortion ended up taking the life of the mother, if during that abortion the mother died, then the doctor would not be protected. And that's what they mean by unlawful. The law wouldn't be protecting that doctor, and thus the doctor could still face criminal charges like manslaughter, for the woman dying. And this, to me, is just them, once again, talking intentionally vague, because they do this throughout the course of their argument, throughout the course of presenting the majority argument. But anyway, so let's see what the past Supreme Court had said about common law. Because remember, this current Supreme Court is claiming that the past Supreme Court either ignored the history or misstated the history, which is untrue. That's just the current Supreme Court 1984ing the past and hoping that somebody doesn't do the research to prove them wrong, basically how I'm doing right now. So let's look at, this is what the past Supreme Court had said during the Roe v. Wade ruling. So this is the common law. This is number 40. This all falls into section number 6. And once again, this is the past Supreme Court showing that, one, the restrictive abortion laws are of relatively recent vintage, meaning they're relatively new abortion laws, and two, that they're based off of mostly a belief system. So that's sort of what they're doing here in section 6. So let's look at number 40, them addressing the common law. It is undisputed that at common law, abortion performed before quickening, the first recognizable movement of the fetus in utero, appearing usually from the 16th to the 18th week of pregnancy, was not an indictable offense. The absence of a common law crime for pre-quickening abortion appears to have developed from a confluence of earlier philosophical, theological, and civil and canon law concepts of when life begins. See, once again, this is going back to this idea that these abortion laws, the way that people perceived abortion, had a lot to do with the belief systems of when life begins. So these disciplines variously approach the question in terms of the point at which the embryo or fetus became formed or recognizably human, or in terms of when a person came into being, that is, infused with a soul or animated. A loose consensus evolved in early English law that these events occurred at some point between conception and live birth. See, at some point between these 2 points. It doesn't mean that it happened at conception and live birth. This was mediate animation. Although Christian theology and the canon law came to fix the point of animation at 40 days for a male and 80 days for a female, a view that persisted until the 19th century, there was otherwise little agreement about the precise time of formation or animation. There was agreement, however, that prior to this point, the fetus was to be regarded as part of the mother, and its destruction, therefore, was not homicide. Due to continued uncertainty about the precise time when animation occurred, to the lack of an imperial basis for the 40-80 day view, and perhaps to Aquinas' definition of movement as one of the two first principles of life, Bracton focused upon quickening as the critical point. The significance of quickening was echoed by later common law scholars and found its way into the received common law in this country. Okay, so the common law that was in this country, abortion pre-quickening, there was a pretty clear consensus, even though there wasn't much of a consensus as to when life really began. There was a consensus, however, that before that happened, the unborn child or the fetus or whatever, or the embryo, was regarded as part of the mother. Okay, so the point is that the Supreme Court, they actually went through a lot. They didn't misstate the history, and they didn't ignore the fact that there was abortion laws in a majority of the states. They acknowledged that. But in acknowledging that, they also put forward the argument that those abortion laws don't make any sense, and that those abortion laws are basically unconstitutional. But, these people in the current Supreme Court, they don't address any of that. They're just basically, they're being confidence men. They're just confidently stating something that is untrue, and then people hear it and they're like, oh, well, it must be true. Why would a Supreme Court justice lie to me? Why indeed? Why indeed? That's a question you should look to answer. Alrighty, so now we're moving on. So, we just read that they either ignored or misstated this history, and Casey declined to reconsider Roe's faulty historical analysis. Roe didn't have a faulty historical analysis. So anyway, respondents' argument that this history does not matter flies in the face of the standard the court has applied in determining whether an asserted right that is nowhere mentioned in the Constitution is nevertheless protected by the 14th Amendment. The Solicitor General repeats Roe's claim that it is doubtful abortion was ever firmly established as a common law crime, even with respect to the destruction of a quick fetus. But the great common law authorities, Bracton, Koch, Hale, and Blackstone, all wrote that a post-quickening abortion was a crime. Now here, and this is also what they do in their argument, is they fixate on the post-quickening abortion being a crime. And they totally ignore the fact that Roe v. Wade basically allows for this. I mean, I guess you can say that not necessarily just post-quickening, but they come to the third trimester part. Now, once again, why not just adjust their ruling? Why not say, hey, you know what? Because science has proven that life can be viable at, 20-something weeks, we're going to put it at the 20-something week mark. Why not do that? Instead, they completely muddy the waters. They kind of misstate what Roe v. Wade is even stating, and they make it as if Roe v. Wade is just allowing for abortions at any time. But anyway, the Solicitor General suggests that history supports an abortion right because of the common law's failure to criminalize abortion before quickening. But the instance of quickening was not universal. And regardless, the fact that many states in the late 18th and early 19th century did not criminalize pre-quickening abortion does not mean that anyone thought that the states lacked the authorities to do so. This is also something that's really funny. I almost skipped past this. So the thing that they cite here, I'm going to read it again. So the Solicitor General suggests that history supports an abortion right because of the common law's failure to criminalize abortion before quickening, but the instance on quickening was not universal. Okay, so the court case that they give to prove that the laws about pre-quickening or post-quickening abortions was not universal, check out when this law was, or check out when this court case was. Because 1850, now I guess this is right around the time that the statutory changes were happening, where people started to separate, or the states started to separate from common law. So, I mean, I have to look into this court case, but what I suspect is the case is I believe that they cited a controversial case, a case that would fall under the pre-Roe v. Wade ruling, So a case that could be up for basically being redebated. But I honestly don't know a lot about this case. But to me, it's very suspicious that they would support their argument with a court case from 1850, the current Supreme Court. I would need to completely read this court case to understand the con that's being pulled off here, and honestly, I don't have the time to do that right now, and I don't think that it's totally necessary, because I'm going to prove that these people are confidence men even without doing that. But that's something that somebody should look into. If you have the time, look into this court case. But once again, it doesn't really support their argument. They're actually furthering the argument of Roe v. Wade by showing that this is something that changed from place to place because it was based off of mostly a belief system. And then another court case that they cite, State of Jacob. Let me see. I think is that also what he is here? Oh yeah, State versus Slagle. It's Jacob Slagle, 83, right? This is another court case that they cite, and it's from 1880. Very strange that they would choose to cite those two court cases from the mid-19th century. So instead of seriously pressing the argument that the abortion right itself has deep roots, supporters of Roe and Casey contend that the abortion right is an integral part of a broader entrenched right. See, once again, this is not true. They did seriously press the argument that the right to abortion, or at least in the first 2 trimesters, has deep roots. Okay, so this is just a straight up lie. They contend that the abortion right is an integral part of a broader entrenched right. So Roe termed this as a right to privacy. So let's see how badly the current Supreme Court is going to screw up the right to privacy. And Casey described it as the freedom to make intimate and personal choices that are central to personal dignity and autonomy. Alrighty, so let's see what the current Supreme Court says about this. So ordered, they say ordered here, so I'm guessing that they're going to comment on ordered liberty again, right? So ordered liberty, of course, sets limits and defines the boundary between competing interest. See, this is all about interest, and this is what people don't understand, is that the overturning of Roe v. Wade gives the government more power to further their interest. Doesn't matter whether it's the federal government or the state government. This gives them more power to further their interest. So Roe and Casey each struck a particular balance between the interest of a woman who wants an abortion and the interest of what they termed potential life. Roe, and then they basically cite that, but the people of the various states may evaluate these interests differently. Wow, so I'll just finish this. The nation's historical understanding of ordered liberty does not prevent the people's elected representatives from deciding how abortion should be regulated. Okay, so let me break this down. Okay, so right here, once they say, but the people of the various states may evaluate those interests differently, once again, okay, why may they evaluate these interests differently? Because of their beliefs. It has to do with religion. And it's not about the people of the various states. It's about individuals. It's about individual rights. It doesn't matter if you are a minority of one. The truth is still the truth. It doesn't matter if one person in a state and everybody else, all the other people, decide, no, we don't want that. It doesn't give them a right to violate this person's individual liberties, their individual rights. People don't have rights. Groups of people do not have rights. Individuals have rights. Now, what's even funnier than that, though, is they once again, they try to get into the people's mind that it does not prevent the people's elected representatives. These are not our elected representatives. These are the representatives of the club. And I've proven this in video after video. These people do not care about us. They can pretend like they do. They're very good at acting, some of them, but they don't give a damn about you. It's all a show. 2 sides of the same coin. Or as some people will say, somebody that I really don't like says, but it's a good saying, they're 2 wings of the same bird of prey, and they are preying on you. Anyway, let's look at the next thing that they say here. Finally, The court considers whether a right to obtain an abortion is part of a broader entrenched right that is supported by other precedents. The court concludes the right to obtain an abortion cannot be justified as a component of such a right. Check this out, guys. This right here completely reveals their hand. Attempts to justify abortion through appeals to a broader right to autonomy and to define one's concept of existence prove too much. Why is it too much? Because those criteria, at a high level of generality, could license fundamental rights to illicit drug use, prostitution, and the like. Okay, so check this out. They don't want to acknowledge that abortion is covered by this concept of autonomy and one's right to define one's concept of existence. This is basically freedom of consciousness. They don't want to acknowledge freedom of consciousness and bodily autonomy or conscious autonomy. Why? Because if they acknowledge those, then those criteria could license fundamental rights to illicit drug use, prostitution, and the like. Right here, it reveals their hand. You see, they need to overturn Roe v. Wade. Why? Because they need to have more control over your body. They need to overturn this stuff because, like they said before, when they talked about medicine, what was that they said about medicine early on in this? They were like, oh yeah, we need to govern abortion with the same standard that we govern other medical practices with. And guess what? Those other medical practices, including forced vaccination. Forced vaccination of children, forced vaccination of school children, forced vaccination of employees. There's no bodily autonomy. And that's really what they're doing here. And they completely acknowledge it when they make this argument that they won't acknowledge this. They're basically saying, no, we won't acknowledge this. We won't acknowledge this right because we don't want to give you these rights to use drugs and to carry on prostitution and the like. That's what they say, and the like. And they make it very ambiguous later on. And why don't they want you to use drugs and carry on prostitution? That's all a belief system. That's all part of their own personal belief system. And that's all, of course, control. They need to have that control. Capitalism cannot have people out there doing drugs and not being part of the system. They need to be able to tax you. There's a whole bunch of things here that have everything to do with corruption, government control, and power. Anyway, what sharply distinguishes the abortion right from the rights recognized in the case on which Roe and Casey rely is something that both those decisions acknowledged. Abortion is different because it destroys what Roe termed potential life, and what the law challenged in this case calls an unborn human being. They're talking about the current case that was being viewed by the Supreme Court. None of the other decisions cited by Roe and Casey involved the critical moral question posed by abortion. Accordingly, those cases do not support the right to obtain an abortion, and the court's conclusion that the Constitution does not confer such a right does not undermine them in any way. So here they're saying, oh yeah, we're not undermining those past court cases, because those past court cases actually don't confer a right to an abortion anyway. So once again, guys, this is incredible sophistry that the current Supreme Court is using. And this sophistry is based off of some lies and some truths, but mostly just straight up lying and 1984ing the past. The doctrine of stare decisis does not counsel continued acceptance of Roe and Casey. Stare decisis plays an important role and protects the interest of those who have taken action in reliance on a past decision. Okay, I can actually stop at this point. Okay, I'm not going to stop entirely here. I'm going to skip ahead, because right here, basically all they're going to be pointing out here is that they're saying that the current Supreme Court does not have to follow stare decisis, which is ruling on past precedent. They're saying they don't have to rule on past precedent. They're like, oh yeah, that's just the guidance, and that the Supreme Court is not restricted to that guidance. And they go on talking about that for a little while. Now, another really interesting thing that the Supreme Court does in their sophistry is they try to claim that what they're currently doing is equivalent to Brown versus Board of Ed overturning Plessy versus Ferguson. And this is really hilarious too, because they're like, oh yeah, Plessy versus Ferguson was using stare decisis, and Plessy versus Ferguson was actually wrong, and Brown versus Board of Ed came in and undid that wrong. And basically the current court tries to equate themselves with being like Brown versus Board of Ed, where they're like, yeah, we're not going to just stick to stare decisis and ruling on past precedent. We're not going to be like Plessy versus Ferguson. We're going to be like Brown versus Board of Ed. And it's really, really hilarious. And then like another thing that they do is they try to make it like Roe v. Wade imposed on the entire country a detailed set of rules for pregnancy divided into trimesters. So this is them working with this sophistry that Roe v. Wade restricted the people, that Roe v. Wade put a restriction on the states and is somehow like a bad thing. Like Roe v. Wade didn't give us more rights, it restricted us from stopping pregnant women from getting abortions. So it's basically like it stopped us from carrying out our religious beliefs. So it's sort of like them acknowledging that the First Amendment should also cover this. Now let's see what else. They point out that like a later court case, I think it was Casey had this ruling where like a state cannot create an undue burden on a pregnant woman in order for her to get an abortion. So they're like, a state can't create like so much paperwork, or the state can't create, basically an undue burden, basically right here. It talks about it here if you want to pause and read it. They're like, this undue burden test on states, it's not workable. Its workability is really hard. Even though it's not hard at all. It's very simple. If you're a state, don't try to create a burden for a woman who's pregnant. It doesn't matter if you think that she's crazy. It doesn't matter if she is crazy. If she wants to get an abortion within a certain window of time, don't make it difficult for her. It's that simple. I know that you have your own beliefs, and I know you feel very strongly about your beliefs, and I know that you think that people doing this is going to lead to the end of civilization. I know the beliefs that you have and stuff, but seriously, you make things worse when you try to push your beliefs onto other people. Because then you convince those other people that, oh, okay, well, I guess it's okay for us to use the government to push our religious beliefs onto other people. And that's exactly what ends up happening. It ends up with less freedom. I'm going to skip ahead to the oral argument, because this video is already really long. If you guys want, you can read more of this stuff over here. I'm going to go ahead and I'm going to go to the beginning of the oral argument. I'm going to leave the syllabus, and let's look at what Justice Alito said while delivering the opinion of the court. Abortion presents a profound moral issue on which Americans hold sharply conflicting views. See right here, conflicting views can be replaced with conflicting beliefs. But they don't want to use beliefs because then the First Amendment can come into play. But yet, right here, check this out. Some believe fervently that a human person comes into being at conception and that abortion ends an innocent life. Right? So here he says belief. Now check this out. Others feel just as strongly that any regulation of abortion invades a woman's right to control her own body and prevents women from achieving full equality. Still others in a third group think that abortion should be allowed under some, but not all circumstances, and those within this group hold a variety of views about the particular restrictions that should be imposed. Okay, now I don't even need to. Actually, you know what? I'll get to. Actually, yeah, I'll read this in a second. But right here, you have to understand the sophistry that's at play. I mean, when he goes from talking about what some people believe, and then what some people feel, and then what other people think, these are completely different categories. These things are not synonymous.
Okay, there is a belief system at play here, which is being acknowledged in just this first statement here. But then they like to step away from the belief system, and this is entirely the belief system right here, that life begins at conception, or at a very, very early stage of conception, or like when the heart is starting to beat. And then it's talking about over here, talking about people's feelings. So right here, this is all sophistry. Now, some more sophistry begins right here. For the first 185 years after the adoption of the Constitution, each state was permitted to address this issue in accordance with the views of its citizens. Then, in 1973, this court decided Roe v. Wade. Even though the Constitution makes no mention of abortion, the court held that it confers a broad right to obtain one. It did not claim that American law or the common law had ever recognized, and then they go on to basically lie. Okay, I don't even need to read any more of this, because it's basically lying here. It's like, it's trying to claim abortion in general, like this broad generalization abortion, and it totally misstates the prior court's argument. It's like, oh yeah, it did not claim that American law or the common law had ever recognized the right to abortion. They did do this. They had a lengthy discussion, and what I read before, that was just like a small snippet of the discussion that they have about the past history of abortion. But the current court completely misstates that, completely lies about that, completely 1984s that, and it just uses a bunch of sophistry. Now, once again, why are they doing this? Because they are steering society in a certain direction.
Can't say one word? Even a guy who can't think says something, you guys just stand there? Come on!